Welcome to everybody in the room. Welcome to all of those joining us online. Before we get underway today, I want to acknowledge that we are meeting on the unceded lands of the Wurundjeri Woi-wurrung people, and we would like to pay our respects to their elders past, present and future, and acknowledge the importance of Indigenous knowledge in the Academy. So my name's Chris Gyngell. I am a co-director of the Health, Law and Ethics Network, Helen. And Helen, as well as the Hallmark Research Initiative in Reproductive Justice, is pleased to welcome you all to the local launch of the book Rethinking Conscientious Objection Healthcare by Alberto Giubilini, Udo Schuklenk, Francesca Minerva, and Julian Savulescu. So few issues really expose the tensions inherent of living in a pluralistic society as sharply as conscientious objection. It obliges us to weigh professional duty against personal conviction. As laws and public opinion on voluntary assisted dying, abortion, vaccinations, and gender-affirming healthcare continue to evolve worldwide, the question of when and on what grounds health professionals may refuse participation has never been more urgent. So it's a great time for this new work on conscientious objection, and I'm very excited to hear more about it. So how we will operate today is we have four speakers. One of the book's authors, Julian Savulescu, will introduce the book and speak for about 15 minutes before we will get 3 reflections or comments on it. And after which we will all join together for a panel discussion and Q&A. So I'm going to introduce our speakers now, but I'm going to do it very shortly because I want to save as much time as possible. So Professor Julian Savulescu is the Chen Shu Lon Centennial Professor in Medical Ethics, the International Visiting Professor in Law at the University of Melbourne, and the Uhiro Chair in Practical Ethics at the University of Oxford. Our commentators are here. We have Professor Tony Coady, who is the Emeritus Professor of Philosophy at the University of Melbourne, and one of Australia's most influential public philosophers. We have Professor Louise Keogh, who is a health sociologist, and chair of the Hallmark Research Initiative in Reproductive Justice at the University of Melbourne. And we have Casey Haining, who is an interdisciplinary researcher at the Melbourne School of Population and Global Health, and who has done a lot of recent research on the voluntary assisted dying and other controversial aspects of healthcare. So we have a great panel today. And I would like to now welcome up Julian to introduce us to make some comments about the book.
Okay, thanks very much, Chris. And thank you all for joining us on this beautiful afternoon. Please help yourself during the talk to different refreshments and food. So here it is, what you've all been waiting for, a great Christmas present for the whole family, from grandchildren to grandmothers. I'm sure they'd all love to have a copy of this book for Christmas. No, you don't need to do that because it's freely available on the web. So today I'm not going to attempt to summarise the whole book in 15 minutes. I'm going to give the most provocative argument, which I think is the most interesting, and leave it to my colleagues to criticise that. There it is. There's the web address at the top, and you can access it for free there. So I think I was the first one to start this off out of all of the authors. In 2006, I wrote an article in the British Medical Journal that had several hundred rapid responses within 2 days. And I argued there that there was no right of conscientious objection to medical treatments such as contraception, abortion or euthanasia, which are legal, consistent with the principles of distributive justice, in the patient's interests and autonomously desired by the person. Now, there are, as I said, many objections to this. Many of them were just, flatly confused. One person said, well, that means that doctors shouldn't object to capital punishment. As far as I know, there's not many prisoners who are autonomously desiring to be executed, so that this principle doesn't apply to that. Now, I'm originally a medical doctor and I haven't practiced for a long time, but I did practice for 5 or 6 years, and I worked in the emergency department at the Alfred Hospital while I was doing my PhD. And I saw, a lot of cases where doctors had views about what should be done with different sorts of patients. Patients who had killed children in car accidents, drunk, people who were self-abusers, drug addicts, and so on. And for all of us, we had to treat the patients equally, regardless of our values in relationship to how that patient should be prioritised relative to others. And this made me think that there were many grounds for what you might call secular conscientious objection. I mean, Tony's had a very good innings. There was a famous philosopher, Dan Callahan, who said that there should be, a limit on how long medical treatment should be afforded to people. That after the age of 75, you shouldn't be entitled to advanced, expensive medical treatment. Now, that's a very defensible view, but if you're a doctor and Tony comes in and he needs treatment, I don't think you should be able to impose that particular view in the absence of some sort of societal consensus that's the way the health system should run. Another example? Yeah, no, don't. I'd treat you, Tony, don't worry. Treatment of animals is another case in point. A lot of people have views about the moral status of animals and their treatment in medical research. It would be wrong of a doctor or a pharmacist to deny treatments to patients on the basis that they opposed animal experimentation. Responsibility for illness. I had a 5-year Wellcome Trust grant on the role of responsibility in the allocation of resources. Many people have the intuition that alcoholics and smokers should have a lesser claim, should be a lower priority for limited organs such as lung transplants or liver transplants. That's certainly a very defensible view, but not one that is currently endorsed by society and not one that I think should be unilaterally imposed by a doctor to deny, say, a liver transplant to an alcoholic. One of the cases that I also wrote up in the early 2000s was of a report into discrimination against patients with Down syndrome at the Royal Brompton Hospital, where adults with Down syndrome were not getting cardiac defects operated on because doctors judged that it was in their best interest to die in their 30s of heart failure than to live on into their 40s or 50s when they would develop accelerated dementia and their parents and carers would die. And I said this was unjust discrimination, but I knew for a fact, having worked here at the Children's Hospital, that children with Down syndrome don't get heart transplants when they actually do need heart transplants, because there's only enough hearts for 2 out of 3 children to receive them. And it's just practice that children with Down syndrome are not, or at least they weren't, 10, 15 years ago, put on the transplant waiting list. Now, if your espoused principle of your healthcare system is equality of access, then those children should be on the transplant waiting list, even though I think there are good utilitarian arguments not to place them on the transplant list. But that would be imposing my views as a utilitarian on those children in the face of a defensible and the articulated policy of the healthcare system. So there are a wide range of other examples where a doctor's values could be very plausible. For example, the allocation of ventilators to people on the basis of age during the pandemic, pre-exposure prophylaxis for gay men who don't want to engage in protected intercourse, transgender management, and so on. All of these are cases where, as Chris said, we start to see a divergence of values in the community. So it's not just that we have Christian values opposed to abortion or euthanasia. It's that there are going to be more and more conflicts in a pluralistic society according to our values. And my thesis was that we should agree on a basic set of values that should govern medicine, and those values are something like respect for autonomy, promotion of the patient's interests, distributive justice, because those are values that everyone can share. And well-being or interests are a common currency. So whatever God you believe in, whatever your background, ethical perspective, something that does matter to you is how well your life goes, and ethics is about viewing that impartially. So well-being is a currency that we can agree on regardless of our particular ethical perspective. And medicine should be governed by those kinds of values that are defensible, whatever somebody's particular set of religious or personal values. So there should be 4 determinants of healthcare. One is the law. Doctors shouldn't disobey the law, but where the law allows euthanasia or abortion, they should provide it when it's in the patient's interests. The just and fair distribution of resources. One legitimate ground of prioritising people is on the basis of agreed principles of distributive justice. and there is a lot of disagreement about those, but in the end we have to decide, is it utility or is it need or is it responsibility? And then that has to be uniformly rolled out across the society. The guiding principle of medicine in ethics is treatments ought to be offered in the best interests of the patient. So if something is in the interests of the person, a doctor ought to offer it. That's their professional duty. So one of the chapters is about professionalism. That's not the way I would phrase it. I think that's Udo's particular sort of perspective on the issue, but it's really about doctors being professional in terms of promoting the interests of their patient and respecting their autonomy. So sometimes people say, doesn't this reduce doctors to just, automatons or robots or servants? It doesn't at all. For example, in the Down syndrome case, I'm free to write articles arguing that organs should be allocated on a utilitarian basis. I'm free to argue that people ought to be held responsible for, their illnesses and given low priority. I can lobby, I can go to Parliament, I can do a lot of things. But what I can't do is impose that value at the bedside over an individual patient. I could even argue with the patient that I don't think that abortion or euthanasia is in your interests, or, that you ought to pursue that. But in the end, if that individual wants a medical intervention that the law entitles them to, that there are resources for, and that's plausibly in their interests, then they ought to receive it, regardless of the doctor's individual values. So there are some countries, such as Sweden and Finland, that don't allow conscientious objection. So they deal with it as, when I was a doctor, we used to do swaps around religious holidays. So we used to cover the Jewish doctors on Rosh Hashanah or whatever the Jewish religious holidays are, and they would cover us on Christmas. But these are all up just for negotiation. There was no requirement for people to have either Christmas or Rosh Hashanah off. And that's how Sweden and Finland deal with conscientious objection. And there's no decrement in the quality of their care. It's not as if talented people aren't entering medicine, because one of the objections you'll hear is that, if we restrict entry into either medicine or different sub-disciplines of medicine, we won't get the best people. And there's just no evidence to support that. There are plenty of people who want to be doctors. If you don't want to prescribe contraception, don't become a general practitioner. Lots of other things you could do. So my view is that we ought to nip this in the bud at the entry to professional training and pick doctors, potential doctors who are aligned with the obligations of that particular subspecialty. The problem with the so-called compromise position, which Victoria and most jurisdictions hold, which says that you can conscientiously object, provided that you refer on to other doctors who are willing to provide that service. Firstly, it makes those people complicit in what they judge to be a moral wrong. And secondly, it results in harm to patients. And I'll go through a couple of anecdotes, but Louise has done a lot of research on this and will be able to tell you actually the facts. So for many years back, I wrote this in 2006, I thought, well, we could probably, adopt a harm reduction strategy and, allow doctors, provided that there are sufficient numbers of others, to object. The reality is that this has tangible harms to patients. And as a rule, I think we ought to adopt something such as Sweden or Finland that just says there's no right of conscientious objection, and we expect you, if you're into obstetrics and gynecology, to perform terminations of pregnancy. So I think we should give greater weight to patient interests and values, unless there are harm to others or, they're distributed justice considerations. Doctors can try to defend and use their values to influence policy, but shouldn't use it at the bedside. And I think conscientious objection can be a backdoor assault on liberalism. So, I mean, this Casey drew my attention to this article just a couple of weeks ago on the ABC website of the problems of access to abortion services by people in remote parts of Australia, or even just in country areas. And this is the story of a lady called, I think it's Rebecca Cahill, who fell pregnant, went to see her GP, in fact had difficulty first of all seeing a GP because the first GP didn't feel comfortable with prescribing medical abortion to her, which results in the termination of pregnancy before 10 weeks. Eventually she was referred to a male doctor who expressed dissatisfaction with her decision, but nonetheless agreed to prescribe that medical abortion. However, she didn't confirm that it had been successful, and by the time she realised that she was pregnant, it was 20 weeks, and it became increasingly difficult to obtain an abortion at that point, and she had to travel around the state and eventually did receive one, but after considerable objection on the part of the doctors involved, and one doctor said it would be easier if you kept the pregnancy, and her partner was particularly angry with her treatment by doctors, and said what it put Kate through is just it's criminal, to be honest. So I'm sure Louise will bring up many more of these stories, but in my view, the question of access means that we should err on the side of the patient, not the doctor. Okay, so I'm going to finish here. One of the things which we do bring out in the book is the idea that in some cases doctors should be able to act on their values. And we call these actionable values. And these are cases where the doctor is going against some policy, but for the very plausible benefit of their patient, either to promote their well-being or to respect their autonomy. So in the book we give two examples. One is of a nurse who refused at Guantanamo Bay to force feed a US prisoner. That prisoner was autonomously refusing feeding, and this, I think, was an example of defensible conscientious objection because it was for the benefit of the patient. And the other example we give is of an Indian lady in Ireland who presented 17 weeks pregnant with a miscarriage, and the doctors refused to perform a termination until the fetal heartbeat was absent, which was the law at that time in Ireland. It's since changed. She subsequently died of septicemia and multiple organ failure. And this is a case just of straightforwardly irrational behaviour on part of the doctor. There's nothing to be said for a fetus and a woman dying, even if you believe the fetus has full moral status. So providing an abortion in that case, even against the law, would have been defensible conscientious objection in my view, because there was clearly a plausible case, a very, very plausible case that it was in her interests and it was respecting her autonomy. So in the book, we deal with a large, all of the major defences of conscientious objection. I won't go into those here. I think that this is not just a question of, although historically it's been couched in this way, of Christian moral values opposing abortion, euthanasia and contraception, sterilisation. I think it's going to be much broader than that. We have broader influence of Islamic values, and many Islamic doctors want to impose their values on the doctor-patient relationship, and increasingly secular values will have an influence over patient care. So I think we need to get our principles right, and I think that the centre of those is not the doctor's values, but the patient, their interests and their autonomy. I must say that out of all the ethical dilemmas that I've faced in 30 or 40 years, I think the moral status of the fetus and abortion is the most complicated one. Euthanasia is a case where you've got an individual typically who's requesting to die, The only person who's going to be harmed by their decision is them. I think that's a very easy case. The case of the moral status of the fetus is complicated, but in a secular society such as Australia, we have to take a position on that, and I think doctors are obliged to respect that decision of the umpire and provide the course of action that's in the interests of the patient. Thank you.
Thanks, Julian. All right, great. So I'd like to hear from Louise as a short commentary first.
Thanks, Julian. Yeah, reading this book, I wished I was half as clever as the authors. I have this just extreme discomfort around conscientious objection and the feeling that it's wrong, but I have not the capacity to lay out an argument in the way that you have to really explain why it's not justifiable. And it's just an amazing example of the value of humanities work to medicine as well, like the partnership between the kind of argument that you can make and then how we can use it in our work in public health to actually try to make things better. So I really enjoyed reading it. And I liked that the authors didn't say, oh, it's simple, there's a simple solution, which happens a lot in public health. Something quite implausible will be proposed because it's a simple solution. And this isn't something that there is a simple solution to. So yes, we've done a lot of work on the harms of conscientious objection, and I think they're pretty well documented. There's quite a lot of suspicion that it is a small amount of people that conscientiously object or that do it in such a way that it harms patients. But what we believe in the research that we're doing is it's quite widespread and that the harms are quite large. And so we've currently got a project going where we're trying to actually calculate how much this is actually harming patients. Like we've got a sort of 1 month trial where we're trying to capture all the objection going on, because it's easy to say, oh, it's just 1 or 2 doctors here or there, and really the occasional patient might be experiencing it, but it's not a big deal. Our position is we think it is a pretty big deal and it is causing harm to lots of women. So what I feel like you helped me do was turn my sometimes frustration, sometimes rage, depending how I'm feeling, into a kind of logical argument, which I think is super helpful for the work that we do. And so the way I would summarize it is, what I heard you saying is that the job of a doctor is to act according to professional standards, the law and patient interests, and that they actually take an oath saying that they're going to prioritise patient interest over self-interest. And patients engage with them as professionals. They don't engage with the doctor based on their personal politics or their moral position. They engage because they've signed this oath, they've agreed to this professional standard, they've taken on this role, knowing exactly what the role is. And so to claim a conscientious objection and actually, especially do that in ways that harm women, is to abuse their privilege and to put their needs above the needs of the patient. And I think the really important point you made, which I think really helps the argument, is that it's a state-sanctioned monopoly provider of a medical service. So women can't choose to go somewhere else. They can't say, oh, well, doctors in my community aren't going to provide it, I'll find a nurse, or I'll get an online provider. I mean, and that could be one solution, is that we just stop doctors having a monopoly over this service and we make it a much broader group of people who can actually deliver it. Providing medical abortion is not very complicated. So one option would just be to take it off doctors. But while they have that monopoly, I think it's a really strong argument they shouldn't be able to object. And I think the question that immediately came to my mind, which you've already addressed, is that, but sometimes what is a professional standard or what is the law is actually wrong, because we have seen changes over time. So what happens in that case? You do want them to fight against things that are unfair or not correct, but what you make the point really clearly is there's lots of ways to be political, to call for change, to argue for change without impacting the patient in front of you and actually making them have a bad experience. So I thought that was really important that you addressed that thing, because we don't want doctors not to have values. We don't want them to be not thinking what's fair, what's the best interest in my patients, how should we be doing this particular healthcare. We want them to think about that, but not with every patient in front of them. It's kind of a separate activity they need to do. So we respect conscience, but not an unfettered right to objection. And I think the other point you made, which I really liked, was that the conscience claims that we kind of tolerate in our society just happen to align with the Catholic religious doctrine. So it isn't that we are saying all conscience matters. What we're saying is these particular conscience that aligns with the Catholic doctrine is the ones that we're going to really support. And you make really good points about other beliefs that people have. We wouldn't tolerate doctors enacting those beliefs in a patient interaction. So it isn't really about conscience. And a point that I've made as well in my work is that it's a political tool. Conscientious objection is a tool that particular conservative group used to push back on reforms that don't align with the religious doctrine. And you make a really strong case. In my work, I've been probably more supportive of the compromise position originally, that if referral is done well, it cannot harm the patient. So and I've certainly seen doctors do referral very well. Like, in fact, the nurse receptionist will make sure that the patient doesn't even encounter the conscientious objector, that another person in the clinic will deal with that patient, or just very respectful referral. But I think you make a good argument that overall that it isn't working, because we see it doing harm because so many GPs don't refer in respectful ways. It also means that work isn't shared across the profession, and we see real problems of workload being heavily on one group and a whole lot of other people not doing that work. And something I think, that's always really bugged me is the only people who don't suffer in the compromise are the objectors. So other doctors suffer, the patient often suffers, but the objector gets to have, complete freedom to not suffer any moral injury. And it has costs for the health system. We see patients getting transferred from one hospital to another due to conscientious objection. So it has costs for the whole health system as well. So I think you make a good argument against the compromise position. So just one question, how do we implement this?
Thanks, Louise. Hopefully we can get to that in some of the Q&A. Okay, I'd like to ask now Tony to provide some comments.
Yeah, I think I should, first of all, lodge a conscientious objection. I have a strong conscientious objection to being limited to 6 minutes in anything that I have to say in public. And I might try and actually carry that objection so far as to go an extra minute or so. This is a very good book, very welcome addition to what's called applied philosophy or practical philosophy and so on. And I agree with one of the things they say quite strongly, that in this area, people and sectional interests can often abuse or distort ideas of conscientious objection. And it's important to stress that, as they do in their discussion, and Julian has mentioned in the course of the thing, but particularly the phenomenon of the medical practitioners disguising as a matter of conscience what are really financial or rather non-moral reluctances to engage in abortion. That's apparently very common in some countries, notably Italy and Portugal, and I confess that I had little idea of it until it was brought to my attention some years ago by one of the authors, Francesca Minerva. Nonetheless, I worry that their argument at times underplays the personal and social importance of conscience and conscientious objection. And though conscientious objection, I should add in bracket, has a double meaning, it can mean the conscientious objection by an individual to performing, or a group to performing some activity that they're called upon to perform, or it can mean a conscientious objection to what is going on in some practice that one isn't actually involved in oneself. And I want to say a little bit about that later, and a bit about conscience more generally. I worry that the argument in some of the books certainly underplays the personal and social importance of conscience and conscientious objection, and overplays the overriding role of such notions as existing professional norms and standards, even of legal requirements. The authors go so far as to say that there's a strong distinction between ethics and more generally understood and professional ethics, and they see the former as concerned with individual morality in contrast with professional morality. They then claim that although the two can be in tension with one another, as Julian recognised, Here, they say, here we are only concerned with ethical obligations that health care professionals have as professionals, that is with professional obligations. I think this contrast they make is too sharp and makes an individual's deep concerns with the rights and wrongs of ways we should live our personal and our deeply communal lives a merely individual or, as they say, personal matter. It's also rather strange to make the distinction, admit that the two dimensions can be in tension with each other, and then claim they're only concerned with professional obligations, when in fact it's cases of such tension or outright conflict that are addressed throughout the book. Conscience can, of course, be a guide, a spur, a warning, or a rebuke to an individual concerning his own actions, indeed, but also, of course, an alert to the morally good or bad deeds of other people and institutions. What makes for difficulties, complexities, and anguish is, of course, that conscience can be wrong, ill-informed, or underdeveloped. But these facts about conscience need to be set against the fact that laws, regulations, and established practices, even those dignified by the name of profession, can also be subject to wrong, damaging, ill-informed, distorted aspects. The appalling episodes in the United States in the 1940s into the 60s, where doctors carried out experiments, often after gaining federal funding, involving injecting jail prisoners and sometimes disabled people with dangerous diseases in order to research the effects, was a Nazi-like violation that had provoked no concern about professional ethics until the many practices were exposed much later, and specific rules brought in to exclude such possibilities. This exposure would certainly have involved objections, perhaps by people involved, based upon the conscience of objectors, though it may also have involved an appeal to them, by them, to what they thought professional obligations and ethics should be, or how existing such principles or rules had been wrongly interpreted. So the two go together there very neatly. Interestingly, in the case of abortion, those doctors who object to performing abortion on conscientious grounds can and probably do consider their objection based on a professional ethical consideration that requires them to avoid harming the patient because they consider the child in the womb as their patient as well as the mother. This interpretation is contestable in many ways, particularly with respect to early abortion, where the objecting doctor has to claim, and usually does, that the developing fetus is already a human being or a human person. I should say in this connection that this idea that the developing fetus or even the embryo is a fully human being with a right to life that cannot be violated is a key part of the Catholic Church's official doctrine, but one that I, as a practicing Catholic, reject entirely, though I think that it is a much more plausible view in the later stages of development, when most mothers, for example, would certainly think of the babe in their womb as a human child. Even there, where such dire circumstances as the imminent death of the mother are involved, we have, I think, a case of weighing up the balance of evils and likely deciding in favour of the mother. On this and many others to do with sexual ethics, such as the ban on contraception, I stand with those groups of Catholics often referred to as liberal Catholics and manifestly evident in the American magazine Conscience. Although the authors argue generally against allowing concessions to accommodate conscientious objectors in healthcare and other professional areas and claim the best solution is for them to quit the profession, as Julian was saying before, and try something else, they admit that people who've been in the profession for many years and face a dramatic change in their professional obligations are a different category from those entering it anew. Examples they give are mostly health-related, but they discuss the military example where people who object to serving in what they consider an unjust war are exempted in certain circumstances from service. But they make 2 points about this, namely that these people have not voluntarily entered the profession, have been conscripted, and that it is common practice that their exemption requires them to undertake other duties related to the war, such as hospital duties or transporting materials. There can be problems about some of these other duties, but I have no time for that. I'm more interested in the case of already serving officers who find their nation engaged in what they conscientiously regard as an unjust war and so refuse to serve. If this happens before they reach combat situations, they may be able and forced to resign. If they are in combat, the matter is vastly more complex, but even so, the military rules of strict obedience to superior orders, the professional principles, and much else of their professional obligations arguably cannot overrule their conscience, and of course they may suffer for that. I think of a dramatic example in the Second World War where a German soldier was called into an execution squad when, I think it was in the Netherlands, when the Germans were retaliating against partisan attacks on them by selecting individual people and taking them out and having them shot. And the German soldier put into that squad objected to doing it and said it was wrong because these were innocent people. And they put him in the group with the rest of them and shot them all. So there are certainly problems involved in doing it, but you have to admire that man. The issue of whistleblowing is another area in which the conscientious objection plays an important role and involves the rejection of organisational or professional rules such as confidentiality. There are very interesting examples of this recently in Australia in connection with war crimes and so on, which I could go into but I haven't time. But we, or at least some of us, have come to realise that some form of protection of whistleblowers is good for the social and political community. The recent exposure of Australian war crimes is an interesting example. That mostly involves the other sense of conscientious objection, where you're conscientiously objecting to things that you've found out about and so on. But in some cases, the people making these objections to the war crimes were witnesses of them and actually involved in what could be regarded as a morally involving way in what happened. So I'll stop there.
Thank you, Tony. And finally, I'd like to invite Casey to make some comments.
Thank you. And just starting off, I'm really privileged to be in such an esteemed panel. It's pretty obvious where I am in the academic hierarchy, so I appreciate the invitation. I would like to echo sentiments to say I really enjoyed reading this book. I think conscientious objection is one of those areas that there's a lot written about, and just when you think something could be saturated, you have a book of over 300 pages and inject new insights into the debate. So I think it's well done to you and your authors for doing that. I really loved this book for a number of reasons, but I think what was really helpful, and Louise set this out, was the ability to set out a framework from the beginning and just keep on revisiting that framework and setting some parameters. I think whenever you develop an argument, it's not unheard of to set parameters, but I think particularly in this debate, it's really important to separate what we define as conscience and what we see as the morality of these issues. And I think what was really interesting about the book was at the start, you and your authors mentioned that we're not getting into the morality of the issues and that you don't necessarily know your own moral views about different issues and where you stand. And I think that's really important because I think you often conflate the two. And so people look at conscience and assume that just because you're pro-choice, you're against conscience. And I think what that does is it just creates this dichotomy, and it's not helpful to have that debate. And what you are saying is, actually, we need to be having those debates, but there's an appropriate forum for them. So if you want to discuss the morality of these issues, that's fine. And there's forums such as the clinical arena, but it's not your job to have that within the clinical consultation. And I guess that helps rebut some of the arguments around conscientious objection that it's bleaching out morals in medicine, or that, you know, it encourages bad laws. When it doesn't do that, it's saying we just need to deliberate them in the appropriate forums. I think it's really helpful to do that for a number of reasons, but I think it then resettles the debate, and then it gets us to kind of rethink our position. And if we are exercising a conscientious objection in the way in which we do that, how then that influences the clinical situations. Because I think what's really difficult about conscientious objection and how it gets played out in practice, and it gets played out differently depending on what healthcare you're talking about, is even if you adopt a compromise approach and it's not the intent of the conscientious objector to actually cause harm or to, you know, condemn the patient, it is that sense that they are being condemned for that. So even if they don't blatantly state that, it is that feeling. It's the distrust of the medical system when you have a health service that you should be expected to receive if it's lawful. I think another effective critique was around the compromise position. And I've had the privilege to work in abortion and voluntary assisted dying for many, many years. And I've always been of the view that you should protect conscientious objection, even supporting both of those health services. But I think what happens that, and you do mention this, that the compromise position is really, it's good on paper, but it doesn't actually necessarily work. And I really enjoyed your example about the mushroom risotto and complicity, because I've been hearing a lot about death cap mushrooms in Victoria. So it was really good to hear it in a different context. But I think that's right. Like, in terms of how we view complicity, whether you are, you know, there is obviously a spectrum, but some people will will fall on different ends of that. But they, even, you know, passing a piece of paper that might have reproductive health options, some will still feel complicit. So in that end, you're not actually minimising the harm. And you could argue, well, yes, the compromise approach, compromise by definition means that you have to give concessions, right? So not everyone wins. But at the end of the day, is anyone really winning in this situation? And so I think the way you set that out was really, really compelling, really intellectually stimulating, and quite disheartening for me that there were so many flaws in my argument that for supporting compromise position, but thank you. But I do think it's really important, because when we think about this from a policy perspective, is if we are going to support a compromise, what are the harms, and what are the harms that are beyond the obvious harms? So some of the harms we always mention is time delays, and that's quite obvious. But I think it's some of the more hidden harms that becomes more dangerous with conscientious objection, and we don't necessarily talk about that, but you do provide examples in your book that makes us think about those things. I think it's also what it re-enlivens, and you ended with this, Louise, of what do we do now? So we've got this problem, we see it's a problem. Do we completely remove conscience? Do we revamp our view of the compromise position? And I think it's a really difficult question, because we see this play out in different health settings and it plays out differently. And I don't think necessarily any policy approach has been, foolproof to date. I think the state does have a role here. So it removes, clinicians out of the game. So if you have a state-sponsored run referral service, so you're removing that from the clinical encounters, and that's helpful. Demonopolising the profession, those things are helpful, but I think sometimes state interventions with the best intent can actually also have the opposite outcomes. Anyway, that's just kind of a food for thought at the end, but thank you again for the ability to comment. Thanks.
Okay. All right, so we've got about 15 minutes for a quick Q&A session. So for those of you online, just if you want to put your questions into the Q&A sections there, I'll read them out for you. If anyone's got any questions here, I'll open up the floor. Yes, that's it.
I have a couple of questions.
You can have one, sorry. I'll come back around if you...
For every doctor who has a conscientious objection for something, there is another doctor who doesn't, particularly when there's market forces at play. So how is a patient going to be disadvantaged in that case?
Unfortunately, it doesn't pan out like that. So Italy, the majority of obstetrician gynecologists have a conscientious objection. So there's hardly any providers at all. And yeah, and the problem is we don't have good numbers on it. So Italy, you have to register. So we know how many have objections there. Here, we have no idea. There's no register. They don't have to let their patients know before they visit. So we actually don't know how many, but our suspicion is it's significant numbers, and it does block access.
Yeah, someone told me that, and we haven't been able to verify this, but in the Netherlands, there's a register of doctors willing to provide euthanasia. The problem with this idea of letting the market decide, so you go and you find a doctor that will perform an abortion or will is that you can literally be killed if you offer abortion services in Victoria. So there have been cases where Right to Life groups have, killed security guards at abortion clinics. So people don't want to advertise that they are providing these services because it's actually a threat to their own safety. So it's not a clear kind of let's just let the market decide and advertise, where you can get these services, because there's such negativity amongst some sections of the community. And I wouldn't be advertising if I was a doctor that I was willing to provide these sorts of services. You don't have police protection. And unfortunately, that's the way the Wild West is. So it is difficult to access the people. And unfortunately, it's the poorest, the least educated, the most disadvantaged that suffer the most. If you're smart, well-connected, rich, you can get the services. But it's the people who don't have those privileges. So the system, is doubly unjust.
Thanks. So there's been a question online which sort of is related to this from Hannah, and it was for Louise. Are you able to give a rough indication of how widespread conscientious objection are, I think particularly in relation to abortion?
Yeah, not really. The bit of work I did in the Grampians, we found about 40% of the GPs in that area were conscientious objectors, and a lot of them were trained overseas. And that's often, I think that's a bit of a pattern in rural areas. It's very difficult to get GPs. We often are relying on overseas trained doctors who've come from different cultures and religions. And we do see high rates in country areas. There's often reports that a woman has pretty much gone to every GP in her little area and there isn't any who will provide. But no, we don't have good overall figures, something we would like.
Can I make a brief comment just following up on what Julian was saying?
Yep.
Following up on what Julian was saying. I think I don't know about the people murdering people and so on, but generally there is a problem about whether or not people know certain things or not, and whether they should. Years ago, I was at a conference here, a philosophy conference. American well-known philosopher Martha Nussbaum came, gave a talk, and I gave a talk, and the Jesuit Frank Brennan, very well-known public figure, a friend of mine actually, gave a talk precisely on this abortion thing. And the interesting thing was that was raised by him or someone was the thing about Catholic hospitals which wouldn't provide abortion, and the idea that nonetheless they could be allowed. This is a Victorian law, but they doctors had to, if approached by someone for this in the hospital, they had to tell them where it was available. And Frank was arguing that that was to involve them in the moral wrong of abortion, to even tell the people about this and so on. And in discussion, I sort of raised some difficulties about this. And that's right, he'd said, because they don't have to tell them, because after all, everyone who in the community now knows what the law is and knows that they can go to another hospital. So I said I didn't think that was the case, because there might well be some, say, young Aboriginal girl who comes from a group that's not very well informed about what's going on with the law and so on, and who comes to the hospital and they say we don't do abortions, and they think that that's true of all hospitals, and this would be an appalling consequence, particularly if it's an early case of early pregnancy. And we got on a bit and he said, well, what would you say? And I said, well, I think what they ought to do is the compromise position of putting up a large notice in the hall or elsewhere, a couple of them perhaps, saying we do not do abortions, however, abortions are available in this, that and the other. And he thought that that was being too complicit in the thing. It seems to me when it gets to that degree of remoteness from the individual having to do something about it, it's a degree of complicity that's unfortunate, but should be tolerated, which is what I argue. Martha Nussbaum came up to me afterwards and said, it's extraordinary to hear two Catholics arguing about abortion in this way. It couldn't happen in the United States.
So I know you've got a question. I just want to say one thing on this. So at least when I last looked at this at the Mercy, which is a Catholic hospital, it's not just abortion, it's actually testing for fetal abnormalities that isn't done. And people don't know that they're entitled to get this testing. So the problem with any of these rules is that it's very easy, and people, want to get around them because they feel complicit. So unless you really have strong regulation and strong requirements, then people are going to find a way to impose their values if they're not taught and forced to, put the patient's values first. So I mean, again, it's a nice idea. Have a sign about, oh, you can get an abortion down the road, but you don't know that your baby's got an abnormality. You're not going to ask for an abortion.
What's the thing about not testing for abnormalities?
There's various cases where they don't offer that,
Well, I mean, what's their rationale for it?
because it'll result in abortion, and they disagree with abortion.
Oh, because the testing for abnormality.
Yeah. Because the only reason it's done is to decide whether you're going to terminate the pregnancy or not. So they don't terminate the pregnancy, so they don't do the testing.
Oh, that's ridiculous.
Well, it is ridiculous, but that's the situation.
No, I mean, it's testing for abnormalities under the description. Testing for abnormalities got nothing to do with approving of abortion. Well, whether the person goes ahead and has the abortion or not is not. I mean, they probably will, of course, but I don't.
So you had yours.
Yeah, sorry, we'll go right at the back first and then you.
Avoiding those fascinating issues for a moment. I may have come in late and I apologize if I do, and just say we dealt with that.
But you speak up a bit. I'm a bit deaf and hearing aids are not working very well.
I came in a bit late, so you may have dealt with this. I apologize. An early slide, Julian may have dealt with this. Do you make the distinction explicitly in the book or otherwise between the exercise of conscientious objection and, say, a professional judgment of the futility of a particular treatment plan or action? And can one be used to cover for another, for example? Is that something that you do?
I can't remember now because this book started in 2018, but I think I do, because what I think, and I'm pretty sure this is in the book, is futility is not a kind of medical fact. It's a value judgment. So, a 1% chance of survival, less than one will be described as futile. Well, I'll take the 1% chance. Thanks very much. So, this is a classic case where doctors' values are imposed on the patient. And what I've argued before is it's legitimate if you're talking about allocation of limited resources to say 1% chance, not cost effective, too expensive to keep you in intensive care for a year, we're not going to do it, versus it's not in your interests or it's futile, which is a judgment about your interests that involves very heavy value judgments. So this is a great example of every day doctors impose their values on patients around the limitation of life-sustaining treatment. And I think it's very difficult to say that a treatment is not in the patient, a life-saving treatment is not in the patient's interests. Much easier to say, well, this is going to be too expensive. There are much better candidates for our intensive care beds. We're going to direct to them.
Medically indicated, which is, of course,
that's just another euphemism for the same thing.
Yes, sir.
Thanks. I just want to say I'm Italian. Few times. That in Italy, one of the issues about conscientious objectors is that even though there is a register, the register is often not public, and the dissemination and collection of information and making the information accessible to people is done by civil society organizations, but it has been only recent. And the conscientious objector model and the exploitation of conscientious objection for other purposes has resulted in entire regions not having where there is no access to abortion. And yes, on the workload allocation, what happens is that a lot of times obstetricians and gynecologists in the public system who do not object end up doing only that. And so there is a lot of professionals who object in order to not be relegated to only doing that. And then I have a question about the hidden cases of conscientious objection. I work on trans rights and trans healthcare from a legal perspective, but what is coming up in my research a lot is that there is a lot of hidden gatekeeping, and which sounds a lot like conscientious objection, but it's not regulated, right? Conscientious, my only understanding of conscientious objection coming from Italy is abortion, and how it's also like a regulated, explicit process of saying, I'm not dealing with this. But then there is a lot of hidden objection, and so I was wondering what would kind of like, how much have you dealt with it, as well into like the regulation, and I don't know, maybe not a very clear question.
Well, maybe I'll just say briefly, you're exactly right. The kind of role, the role doctors' values play in delivery of care isn't just limited to abortion. It applies to, for example, providing IVF to gay couples. Some people will say, I don't agree with that. And so they'll find various ways not to participate or to obstruct people who are entitled to access that service now. And the same with, transgender care. People will have different views about that, and their view will typically prevail. This is a case where I think you need to know what the long-term follow-up is for whether it's in the person's interests, whether they're properly autonomously desiring it. And then if there's good evidence for that, then I think you ought to be providing whatever that intervention is, not on the basis of your own values or your own idiosyncratic interpretation of the evidence. So you're exactly right. I think this, that's why I think we sort of think, it's all about abortion. But it's not going to be. It's about, as medicine, can achieve patients' values in lots of different ways, it's going to be more, the patient's values will come in conflict with the doctors, and we have to decide, okay, how much are we going to give weight to doctors' own values? I mean, just to answer Louise's question, what would I do, right? I mean, having worked in this for like over, now 20 years, I would give up this immediate, right to conscientiously object that's in Victorian law. I would make sure that people who were entering different disciplines were prepared to take on those roles at the beginning, but the job will change, so they may well have new objections in the future, and I would educate them to put the patient's interests and values first. But at the end of the day, I don't want somebody who doesn't want to be giving me care. So I kind of have a very limited place for sort of compromise, because at the end of the day, if you can get somebody who is actually going to treat you, well, and I think people do have to learn to treat patients well, even if they disagree. But at the end of the day, if they really are going to be half-hearted about that, you don't want them looking after you. So I think there has to be some sort of exit somewhere for people, but I think it's just too big now. There's too many people, as you see in Italy, everyone's leaving the door because, it's unpleasant, it's not financially lucrative, it's just easier not to do it. So there's too much freedom. I mean, there's always a question of how much freedom should we have in balance. And in this case, I think there's just too much freedom for doctors.
Yeah, I'm just going to have one last question. Yeah, please.
Follow, perhaps linking to that. I mean, there are many questions that I would love to ask, but here's one that links to this particular problem. So if we go down the line that we just don't permit conscientious objection, like your suggestion, and we know that there are already covert practices of sidestepping the issue, so to speak, isn't that going to make this problem of covert practice more because people don't actually even, it's like the prohibition problem. Yes, so you kind of now have to find alternative ways not to do what you want. And doctors, I mean, I've worked 40 years in public health and 30 of them as a medical doctor. Doctors are very good at doing that. It's a middle mechanism.
I think that's a very good consideration. It's a consequentialist objection. So we need to look for the evidence of it. And we also need to look at places that have done things differently, natural experiments. So I think Sweden and Finland are such. So it would be interesting to sort of see to the degree to which doctors do get around it or why they don't get around it. So at the end of the day, I think you've got to have some foundational values. And I think all of us have the foundational value that, patients should, get what promotes their interests. They ought to be respected. Question is, what is going to best achieve that, given that doctors have these variable values? And my view is we've just immediately thought that this conscience is so privileged that we need to protect it at all costs, and too much weight has been given to that. Now, what precisely is the best practical, solution? I don't know. I mean, partly it's empirical, like you say. Maybe we do need some sort of compromise, to actually deliver good patient care. But I think we need to be investigating it systematically rather than taking a deontological position that conscience must be protected at all costs because it's so sacred. And that's the current position.
Okay, great. Very strong words to finish on. So I want everyone to thank our speakers and panelists. Great. And thank you very much. So yeah, thanks. We'll end it here. Thanks all.